not know, my name is Ryan Rehberg, and if you are here for an estate planning seminar, if can you control from the grave, or if you're incapacitated, then you are at the right seminar. If you're looking for something else, sit back, relax, have a good time. I hope if you have not had the chance that when we're done, you get a chance to go upstairs. We have the open house going on up there. There's a candy bar. You've got to go figure out what that means. And the rest of the attorneys will all be up there to be able to answer questions for you. So there'll be a lot of asking. If you want to set up a meeting to meet with any attorneys, great. We have a board that will tell you about who the different attorneys are if you're not familiar, or trying to remember who you've met with. But today's time was designed to do a couple of mini seminars. So we'll do one now, and we'll be doing the same one this afternoon. And the seminar is on incapacity issues. Before we get too far into that, I'd like to make some introductions. Today I actually have two very special introductions. You could come in too. For those of you who have been with our law firm for a long time, the law firm is Rehberg Law Group. It was started in 1968 by Hugh and Jean Rehberg. And I have the privilege of my mom being here at the seminar, and her twin, Joan. Jean and Joan. And Mom, I've been asked one question already. Was it raining on the day you opened the office? I was 9. I don't remember. So, okay, good. The other privilege is a young lady that just walked out that way. This is Carrie. Carrie is one of those who's been with us the longest. I very much appreciate this young lady and her family. It was her mom and dad in youth group with me that I needed an intern for a summer, and was so afraid to ask that I went to her parents. And 19 years later, she still puts up with me. And even better than that, the young lady at the desk is actually Sandy Rehberg. She doesn't usually get to be at our seminars, but it was her assignment to come down today. So I have a privilege of having some very, very important people to me here today for the seminar. So I want to make sure you get those introductions and know what's happening. So let's talk about controlling from the grave and incapacitated. If you've been around for a while, you have been told, of course, you cannot control from the grave. I'm here to tell you, of course you can. There are some really good ways to do it. And that's what we're going to look at today. We will dispel a few myths that people have heard but may or may not be true. We will also talk about what is true and what are options you have available to you. In addition, if you're one of our clients, you already know that we have our email newsletter, we have our annual in-print newsletter, and that if you want questions, please let us know. Just call us. We can't help you if you don't call, and we don't bill you for those phone calls. So it's real important you see us as a resource to you. But as you know, we only do estate planning. And so if you need a referral in another area of law, feel free to give us a call. We keep track of other attorneys who do a good job for our clients and are more than willing to recommend them to you if you need that opportunity. So let's talk about controlling from the grave. And of course the answer I said was yes, you can control from the grave. But it's a matter of knowing how, knowing the right way. So the topics we're going to talk about is what is estate planning and how do you use that to control from the grave. We're going to talk about what happens if you're incapacitated. The issue is we are living longer, but we don't always know what we're doing. So I was reading the newspaper about a year ago, and there was an article that said medical science believes that within the next generation, they will make enough improvements that we will be able to live 150 years. Really? Okay. So I read it again, and I looked at it one more time, and then I noticed a very unique word. They will be able to get our bodies to live 150 years. So if I become incapacitated at 90, my family's got to deal with me for another 60 years not knowing what I'm doing? Not so sure that's a good idea. And for those that are concerned about their finances, you're probably definitely sure it's not a good idea. Since then, they've not printed any more articles like that. Surprise. We will also look about the fact of what should you do about your beneficiaries. If you have been accumulating money throughout your lifetime, the goal would be make sure you enjoy it for as long as you're alive. And there are those who say, when you die, do it spending the last dime. Okay, but what if you die and you have dimes left over? Who do you want to leave it to? And that's what we'll look at today, is how do you make sure that the people you're leaving it to are the people you want to leave it to, and it'll be done in the way you want them to leave it to them. There are seats still in the very back. There's still more. We will talk about estate taxes briefly, just because it's an annoying subject and people still have questions about it. And the last thing we'll also talk about is when should you review your estate planning? Because as I said, we've been around for now 50 years, and we have third and now fourth generation of clients. And so it was, as we look at that and look at multi-generations and how that should work, you want to look at what do you do? When should you come back and look at it if you're providing for that many generations? So let's talk about it. What is estate planning? Well, if you've been with our group, we say estate planning should give you peace of mind and control. That should be the end result. You should be able to finish your estate planning, walk out the door and go, I am ready to die. Our record is 3 hours. We do not encourage you to beat it, but we want you to know that that is the case. So please be aware that there is proper estate planning you can do even on a very short-term basis. Yes, that's actually the truth. So when you take a look at about what is peace of mind and control, it is you being in charge of yourself and your assets for as long as you can be. And when you no longer can be in control, that you appoint who will be in control as long as you're alive. And then when you die, because we all sign up for that when we sign up to come in, you're in control of who's going to be in control of your assets. Even to the point that you are in control of who they are going to go to, when, and how. That's control. That's peace of mind. You need to make sure that your documents provide and allow for that. If you can't say that, then it's possible you may need to update your estate planning. So being in control is very, very important. And having peace of mind. And I was doing a seminar, and I found out later she had 3 kids, but only her daughter was with her. And there was about 200 in the seminar. I was there at the school district. And at the break, there was a beeline. And you can see it in the crowd of this gal, elderly gal, and what turned out to be her daughter. The reason was she had 3 children. The other 2 were in their 30s, and the other 2 were autistic or Downs. And she had been looking for her whole time where those kids were alive of what do you do for autistic or Downs kids. And no one had told her there was a way to handle that. And when she heard that in the seminar, the relief of what she could do was huge. And in a bit, we're going to talk about distributions. Because remember, we have 50 years of creative clients with creative beneficiaries. So we'll talk a little bit about that in a minute, too. So let's talk about what happens if you don't die, but you're incapacitated. Well, there are incapacity documents. We talk about those as being 3 different ones. The first one is a financial power of attorney. This is who can help you pay your bills, who can sign for you. There's also a medical power of attorney. Who talks to the doctor if you cannot? And the third is a directive to physician or living will. We call this the please unplug me document. The powers of attorney. On the financial power of attorney, if it was not done by us, take a look at it. And you want to really ask yourself 2 questions. The first one is, do you still like the people who are in control? Because sometimes people don't look at their documents very frequently. And when I talk about those people who are in control, the second half of that question is, do you have more than one? Because if you only have one, people don't always agree to die in the right order. So what if the person who you appointed is already themselves incapacitated, or they themselves have already passed away? Who's next? And do you like that person as well? Another thing that I would encourage you to do is look at your power of attorney and see how old it is. Why? Do they grow stale? Do they go out of date? The answer is legally they do not. However, some institutions are big enough and write their own rules and pretty much say, if it is over this certain amount of time, we will not use it. We won't honor it. So you have to be careful that if you have one that is getting too old, and mind you, institutions declare old their own way, you might want to update your power of attorney. But before you do that, if you have a common bank or financial institution, take the power of attorney to that bank, to that institution, show it to them and ask, will you still honor this? Don't go pay money for something that will still work. On the medical power of attorney, again, remember, sorry, one more thing on the financial power of attorney. Do any of you, and I'm looking over the crowd, so some of you may do it, but do any of you have minor grandchildren that you babysit? Grandchildren over your house, or great-grandchildren? Only a couple of you. I know you do. The issue is don't, okay? Don't do it again. Why? Because if they get hurt at your house and you take them to the hospital, you get locked out of everything. One of the laws that has changed recently on financial powers of attorney is to allow people to put a temporary guardian over minor children in their powers of attorney. So for those of you who have grandchildren or great-grandchildren that are minors, make sure you talk to your child or your grandchild and tell them to update their powers of attorney. Very, very important. And on the financial power of attorney is where you put that. Now, the reason why that's real important was before you could do that, my son was over at my sister and brother-in-law's. My son had just learned to ride a bike. My son hopped on his cousin's bike and decided to go for a spin, with my cousins telling him no. Not really thinking much, the fact that the driveway goes straight down across the street, hits a curb and a hedge, and you can vault it if you don't be careful, and then you land on your elbow. Now, my brother-in-law is an ex-football player and coach, okay? I don't see anybody here that's as tall as him, and no one is as wide as him, okay? He calls me, hey, I think Alex hurt himself. Yeah, if I had a dime for every time. Well, we're going to take him to the hospital. No, don't, just ice it, he's probably fine. Ryan, arms don't bend that way. Shoot. Which hospital? Well, they took him to the hospital, and as soon as they checked him in, then they asked, so how are you related to Alex? Well, I'm his aunt and his uncle. Oh, we can't talk to you. That's the HIPAA code. My own sister, before they had changed this law. So now that the law is there, and you can do that, it has become a very, very, very important tool. If there's any minor children or grandchildren at any age, you do want to make sure that you get a power of attorney to allow a temporary guardian for them. The medical power of attorney is as important too, because you want to make sure that the person talking to you, or talking on your behalf, has your best interest at heart. They are making medical decisions for you because you can't. In the same way, if in fact you're at a point where you need to no longer be managing your affairs, at that point in time, they're the ones who control the please unplug me document. They are also the ones that control whether you have organ donation or not. Make sure you trust them. Now, there is one person who you should never put on a medical power of attorney, and that person is?
Your doctor.
You can't do your doctor. Spouses are good.
Your lawyer.
No, that, I won't do that unless you're family. That's it, okay. The kid who says, am I in the will? Yes, Eldon. Oh, yell at me, please.
What about the situation where your kid, their spouse, are going away for a few days and your child's sitting their kids?
What was the question?
And
I'll repeat it.
And they give you a piece of paper that says, da-da-da, have my approval to take him to the hospital and get treatment.
Right.
Okay.
The question is, what about what we all did? My mom did this. I did this. If you're going away for the weekend, you write a note. Hey, while I'm gone, Richard's going to be taking care of my kids. He's got my authority to handle things. Just give him a note. Yeah, completely illegal. Can't be done. And we all do it. But because of the HIPAA code and because too many hospitals have been sued, that never has been valid, and it will depend on the hospital. It will depend on the doctor. They legally are not allowed to honor that unless it's also been notarized. That's what makes it the valid document. That's why it's in a power of attorney, because the power of attorney has a notary. And the reason for that is the hospital wants someone else to blame. Bottom line. So those are powers of attorney. The third one is the incapacity, is the please unplug me, and most people understand that one. The last of the things you can do for incapacity is a living trust. And we talk about a living trust, and on your handout on page number 5, at the very bottom, for most of you who have been to our other seminars on estate planning, you're familiar with this chart where we talk about the pluses and the minuses of wills and trusts. And one of the things we talk about is that different tools were created to do different things. I was with a client, and he's a contractor, so he does a lot of excavation. And I went, oh, this is easy. How many different tools do you have for your excavation company? He goes, hundreds. Do they all do different things? Darn right. I said, that's estate planning. And for people who want to do a will, they have to understand that a will is designed to go through probate, and a will is only death planning. That's what it was created to do. Don't be surprised by that. For families who incapacity, whether it be Alzheimer's, dementia, Parkinson's, or some other medical reason, believe that they will have incapacity issues, a revocable living trust was created to avoid a court-appointed guardianship. So if that is a need or a concern of yours, make sure you talk to the attorney about that type of a document. Remember, estate planning is a series of tools that are designed to accomplish different tasks. Figure out which task you want to accomplish, you'll know what tool to use. Okay? So any questions about incapacity issues before I go on to the next one? The next one's the fun one on beneficiaries.
So,
Yes.
do you carry these documents with you to the hospital? How does that work? How do they know?
The question is, do you carry the documents with you to the hospitals? How do they know what you have? Normally, the answer is yes. For most of our clients that have a notebook, one, you want to let those close to you know where the notebook is. And in our house, by the way, third shelf up on the right in the den,
Gotcha.
just in case you're over in an accident. I mean, who breaks into a house to steal a notebook?
I might be distracted by
Okay.
Disney stuff.
It's next to the Disney stuff, yes. So when you do that, and when you take that to the, if an emergency would occur, any of my family will grab that notebook and go to the hospital and will have everything they need. So it is important that you have those available. I will say that some people have had us scan their documents and email them to them as a PDF. They'll put it on a disk and they'll take that wherever they go. Certainly if they're Sunbirds, they'll do that, so they have one in both states. I also can say that we've been called by other states from hospitals where they'll ask us to email it to them as well.
Is this the wrong place to ask for about safe harbor?
Safe harbor, that's next.
Okay.
I will deal with that one. Any other questions about incapacity? Okay, let's talk about what do you do for your beneficiaries. And the first beneficiary I want to talk about is actually your spouse. And when we talk about spousal beneficiaries, the issue becomes, what do you want to do with your assets? You can give your separate property and your half of the community property away to whoever you want to. Do you really want to give it all to your spouse? And everybody talks about advanced estate planning really occurs because you have too much money. It was actually around the year 2000 that estate planning attorneys began to realize that more people did advanced estate planning because of second marriages than how much money they had. It's been that way for years. And so one of the concerns is, what happens if I die and I remarry? Can I use my example even with you here? She's heard it. Okay, this is my wife. I love my wife. She loves Disney as much as I do. She loves football on Sundays. Most of those football things, auctions, she won when I quit bidding. It's really freaky. I go, no, let's not do that here. Okay, 200, right behind that guy. Where'd that number come from? So yes, we love Disney, we love football. Oven fried chicken. Okay, we don't go to Kentucky Fried Chicken. When our kids would come home from the weekend early on, there were times they'd ask for that for the meal. And by the way, it's Christmas time almost. I know there's a couple holidays between now and then. We call this almond roca time. We don't buy almond roca. For those who know her almond roca, yeah, there were people who would hire her to make almond roca for their Christmas party. In our office, it's called Christmas crack. That's right. Yeah, Christmas crack. It is good. If I'm dead, there will be a line at my door to marry that woman. Now, as long as I'm dead, we're okay with this. But if I am, do I want to give her all of our money so that the hunk in the bimbo clause, the hunk marries her so he can take off with it and my boys don't see it? Maybe. But there are times I may not want to. And in that case, in taking care of the spouse, I may want to go ahead and do something to protect her. Now, between the two of us, she is the much better driver. So in her case, she may be saying, look, if I give all the money to Ryan and he gets in an accident, hits a soccer mom, kills a couple of kids, we got a problem because all the money's gone and nothing's for Alex and Adam. If that's her concern, then she can't give it all to me. But the next one is estate taxes, which we will come to. And many times in taking care of a spouse and providing protections for the spouse, you don't give it to them outright. You put it into a trust for their benefit. The last item of a spousal situation is what's called an extra supplemental care trust. It's also called a special needs trust. And about 8 years ago now, which attorneys are really good at doing this, an attorney south of here created a new name for a trust that we've been doing for 45 years. They now called it a safe harbor trust. Please understand that is not a new document. That's been around forever. Okay? What it means is there are times when a family is concerned about all of their assets being taken by the government because they may need medical needs. And so when you're dealing with elder law issues of incapacity and lack of funds, then that's an important time to take a look at another form of a trust where you're taking care of the spouse without it depleting all the assets. Now, for those of you who know our firm, you know that I am very, very thankful that this board has 6 people on it. Not 1, not 2. 6. And currently, Jerica and Grayson are both the ones that are working in the area of elder law. Grayson's learning from Jerica, but Jerica's been doing it for a long time. So if you have a family situation where you're concerned about Medicaid or government assistance, VA accredited assistance, any types of issues, be aware we now have resources for you that we didn't used to have. For those of you who have worked with Mark Albertson when he was with us, and I'm hoping he makes it today. He's been invited. We're hoping he gets here. And he used to do some of this, but since he had left, we hadn't had anybody till a couple years ago. So it's very important, if that is an issue for you, you meet with her and set it up to me. Yes, please.
Is it only for spouses, or can you use it for, let's say, a brother or grandchildren who may need who have special needs?
Correct. The question is, can this type of a trust be used for everybody?
Would you repeat the question?
Yes. The question is, can this type of a trust, an extra supplemental care or a special needs trust, be used for more people other than the spouse? And the answer is absolutely yes. In fact, the way it is used more than not is autistic or Down's children, because they will be on government assistance their whole life, and because of that, you can't leave them an inheritance or they lose their government assistance. And that was the issue of that seminar I was doing for the school district, that it was important that they have that need taken care of. Again, the Safe Harbor Trust attorney who was touting those was mainly touted in between spouses, but we have used more for children than we've ever used for spouses. If you get involved with the area of special needs, they say that over 10% of the families in the U.S. have some correlation, child, grandchild, niece, nephew, of a special needs child. And so it's a huge area being not really addressed, but we've been doing it for years. Okay? So let's get past the spouse issues. And if you look at the bottom of your page 7, now we can talk about the kids. This is where I have fun with my own kids. Alex and Adam are now 27 and 23. Can you believe that? 4. Shoot, lost that year. Can you believe that? Jean is one of my past neighbors. I love this lady, and so she knows them. Yeah, she knows them all. So they're now 27 and 24. Now, if Sandy and I died together soon, should we give all of our assets outright to Alex and Adam? Okay, she shook her head no. She's correct. No. Carrie's going no too. I know, she doesn't too. Why not? They're 27 and 24, and they're boys. The latest medical study is, guys, we don't get our brains until we're 30. Not only that, we still only get to use half. Still not sure that's fair. Ladies, they still say you're getting yours about age 25. I'm not a medical doctor, I don't know. But either way, why would I do that? Why would I not put some protections in place for my boys? Even to the point that for our case, they're no longer minors, which you want to put guardians in a power of attorney and in your will. But it's because of the age they are that I want some protections for their money. Remember, an inheritance is a privilege, not a right. An inheritance is a privilege, not a right. So for us, we decided to do something different. Rather than be outright, you can set up what's called an irrevocable testamentary trust. It goes inside your will, it goes inside your living trust, and this irrevocable testamentary trust says it does not come to you outright. In fact, it will be held for your benefit for a period of time. And between now and when you turn, you pick whatever age you want, 30, the court terms they like to see is maintenance, education, support, and health. It can help them get it through college. It can help them start a business. It can own a home or help them get a home going. It can do all sorts of good things. It can also be held back very, very restricted if in fact they're dealing with drugs or alcohol, a bad marriage, a bad lifestyle, whatever that's defined by. That's what a testamentary trust can do. For Sandy and I, when we first did our estate planning, we put 25 because the kids were this old. 25 was forever. Then they got to their teen years. 30's looking better. Then they got to the 20s. You know what? How about 1/3 at 30, half at 35, the remainder at 40? Why did we choose those ages? Because it made us feel good. That's about it. They are your beneficiaries. You choose what age or ages you want. And we have everything. We have those that use the triplets, we have those that use the doubles, we have those over 5 different periods, 30, 35, 40, 45, 50. We have those that set up as a pension. From which of our kids is going to have a pension? So from 0 to 40, maintenance, education, support, and health. 40 to 60, are there any financial planners in here? I don't recognize. There you are. Okay, I knew saw one, but I didn't know where you were. If I decide to distribute out 5% only a year for 20 years, that principle will stay about the same. Should. Good advisor, you'll get it there. Good advisor will not promise either, by the way. And then once they reach 60, make it a pension. 1/20th, 1/19th the next year, 1/18th the next year, 1/17th the next year. It's your money. What would you like? We have kids who are dealing with drugs and alcohol. Trust for their life. There you go. Others who want to go and give them $1,000 a month, that's gone. Now, then there are the trust babies. They're the ones waiting for mom and dad to die so they can live off the fat of the land. Okay? We've used this provision I'm going to tell you about a half a dozen times, almost maybe 12 times now. And so far, most of those people haven't died yet. Darn it all. Because it's going to be really fun. And most times, you no longer read a will. You just send them a copy of the trust or the will. But in these situations, the kids are not in charge. Normally it's our law firm or another corporate trustee, and that will be the time you will call the family members together. And when you do, a kid who wants mom and dad to die so they can live off the fat of the land has 2 questions. And they are? How much? When? Absolutely. So here's your provision. For every $1 from your trust, you can have to match what is on your income tax return. You want to live off the fat of the land? You get nothing from it. You want to work? You can have something from it. Your call. It's a nice provision. Can't wait to see how they respond to that one. It'll be fun. Okay? So there's a lot of different things here. The special needs trust is actually on here also for kids and grandkids. We also have ones where you can be helping them in doing different things. We have a client and their kids are in their 40s, probably early 50s now, and they are in the arts. They are gifted in the arts. But there's two problems with the arts. One, no money in the arts. What's the other problem in the arts?
Unpredictable.
Unpredictable relationships. Relationships come and go in the arts. The last thing they wanted to do when they die is give all their money to their kids, because their kids have been through a half a dozen relationships, never married, never committed any of them, so which one's going to get all the money next? So what do? Put it in trust till their kids were 70. Okay, you haven't figured your marriages out by then? You never will. But before 70, it helps them start their business, helps them do more schooling, helps buy a house. They're incentive trusts. Young kids, we have incentives. Graduate from high school, get in a 4-year degree, get an undergraduate degree. So much for a house. Now be careful with that one. Limit it. Don't say, we heard this one later, it was not our client, the trustee shall buy a house for my child from the trust. That was, yeah, some of you figured this one out already. I saw your faces. That's exactly what went wrong. The kid wanted a house at about age 23, 24 of about $750,000. And there was no way for the trustee to be stopped because they didn't put the right provisions in. How long did it take that kid to sell that house? Be careful. Yeah, 90 days. That's about right. Don't do that. Be careful with your provisions. You can put incentive things in here. The last one I really want to talk about is a dynasty trust. That just sounds impressive. It actually is impressive, and it's actually done by a lot of people, and many times it really doesn't matter how much money you have. But what in the world can a dynasty trust do in Washington State? It can last 150 years. Why? Two great reasons. One, while it is in trust, the IRS does not get to assess estate taxes on it again. Not until it's done and distributed out, or whatever portion is distributed out. That doesn't happen. The other thing that we've had people use in a dynasty trust for is the family vacation home that has been within the family for generations. And now, rather than being dispersed amongst everybody, they put it into a trust, fund it with a life insurance policy, and it can be there for generations to be using it. We've had others use it for a family bank, where there's a committee of family members who dictate how it will be used for down payments on houses or businesses or education. There's a lot of good things you can do with a dynasty trust. So be aware that is a tool that is available to you. These are your beneficiaries. Who would you like to leave it to? An inheritance is a privilege, not a right. You dictate what you like to do. Estate taxes. I will briefly talk about this. The state of Washington has an estate tax at $2,193,000. That includes proceeds of life insurance in your name, equity in your home, securities, businesses, anything else you own. If you're over that, you end up being able to have tax between 10 and 19% to the number one charity, the state. Number two is the U.S. government. And in doing that, if you are married, you both can do proper estate planning to where you both preserve your 2.193 and not have estate tax until you're about 4.4 million. The federal government, remember, the federal government only taxes the rich. You hear that every time they deal with this on an election basis. They only tax the rich. So 2 years ago, you were rich if you had 5.6 million, and then January 1st the next year, you were not rich until you had 11.2 million. You just became poor between that? Okay, but remember, if you're not concerned about the federal estate tax limit, There's a sunset clause. Choose carefully what year you die. Because when you get to 2026, it goes back to what it was supposed to be. Right. What will that be? Oh, they haven't clarified that. Some are saying 1 point, because I've heard that one. Some are saying 2.5. Some are back to the 5.6. Others are going, they'll abolish it. Okay. And of course, remember, the battle cry is, they will never change it again. Okay. So be aware, if you have concern about state of Washington estate taxes or federal estate taxes, there are tools you can do in the forms of gifting. There's even some categories in here of gifting methods you can do. Dad, I loved his phrase, gifting while you're alive is what he called warm hand giving versus at your death, which he called cold hand giving. He also told the story about a client of his who played a trick on his kids. In the middle of the year, when nothing is going on, no birthday, no holiday, no reason, give each of your kids a chunk of money that is more than they would expect they would ever get from you. And then sit back and watch. And in doing that, first of all, they got to pick their jaw up off the floor and go, what's this? Oh, we just love you. Just letting you know. Just watch. I've had clients do this. They came in afterward and changed which kid was in control of their estate. They've also come in and changed their distribution provisions to their kids. Nice trick. I like that one. So there are distribution things you can do. There are gifting things you can do. Be aware of that. If that's a concern of yours, please talk to your attorney. And if you don't have an attorney, feel free to talk to one of us. We're all here. So that's the issue of estate taxes. For those people who want to, and for gifting, yes. Hello, dear. Good to see you.
Hi.
Hi.
Are they taxing over the 2,193, anything over, or the entire amount if you go over?
State tax limits. The state of Washington taxes only what is over the 2.193. But that is why it is a 10% start. Because they actually have all the way down to 0. And if you are not a U.S. resident, there are issues of taxes below that limit. This is applying to the U.S. residents. You'll notice that the federal tax limit is 40%. They actually have a scale below the 11.2, different from the 40% if you're not a U.S. resident. So they only tax what is above, but that's why the percentage above that is not starting at 1. So that's what they do with their limits. Okay? Any other questions about gifting? Then let me talk about the issue of when should you review. From our perspective, we call it birth, marriage, death, 4 to 6. Someone who is born should be included or excluded. If they are born and you have a child or a grandchild who's autistic or Downs, you need to figure out how to handle that. If someone's born, should they be included or excluded? Marriage. Does the in-law become the outlaw? There's ways to deal with that. Our most fun story about this was one of our clients who came to me to modify their amendment, their living trust. The reason they came is their daughter had married a gentleman who was well-to-do. And they thought that was fine and great, and he seemed to be wonderful. And about 2 years into the marriage, finally she had the gall to ask him, by the way, you've never said where you came across your money. I sued my parents for my inheritance. That wasn't the kicker. And if we run out, we'll just sue yours. Yeah, we took care of that.
Whoa.
Yes.
I have a question about gift tax. You know, if you did a gift 30 years ago and you can't find a copy that you submitted, can you request the IRS to get a copy?
The question is gift tax. If you did a gift tax years ago and you can't find a copy of that gift tax return, a 709 gift tax return, can you request a copy from the IRS? The answer is yes, because you know darn well that if it deals with the government getting more money, they've kept a record of it. And they may not be able to supply you with the return, but I'm sure they'll tell you how much it is. But the issue of gifting, and I want to hit this really quickly, is people have been told you can only give $15,000 per person per year. That's not a correct statement. The full statement is you can give $15,000 per person per year without having to file a gift tax return. You can give away as much as you want to give away. And right now, with the federal limit being at 11.2 and the state being 2.193, there are some people out there that are giving away millions of dollars because they will never hit the federal limit and they want to get under the state limit. So there are gifting ways you can do it, but you know darn well the federal government will watch that. And the state of Washington, they don't care how much you gave away during your lifetime. The state of Washington just wants to know how much you have when you die. Okay? So, when do you review? Birth, marriage, death? Death, that's the next one. If you have someone that is your beneficiary that has died, if you have one of the people who's your power of attorney or trustee or personal representative, if someone has died and you think that you will receive an inheritance, all of those are good times to talk about it with an estate planning attorney, because it may affect what you've done in your estate taxes or in your estate planning. The last is every 4 to 6 years. Every 4 to 6 years, you should get it out, look at it, and ask yourself, what was I thinking? Make sure your goals and desires haven't changed, because if they have, do it. And if you're one of our clients, we now start sending out a letter every 4 years if we haven't seen you. And it pretty much says, review your documents. Make sure the people in control are who you want in control. Make sure that who is going to go to is who you want it to go to. And if you have assets, living trust or will, make sure your beneficiary designations match your estate planning still. All very important things, and especially that beneficiary one, because with all the different bank mergers, there were many times our clients were told, yes, of course we kept your beneficiary designation. And then when they went into the bank to ask for a copy of it, not there. Always good to check if there's a bank merger. So you should review birth, marriage, death, and if not, every 4 to 6, get it out, look at it. If everything is fine and you get our letter, send me back an email and say, we're great, send me another one in 4 years. If not, call us back and go, hey, need to meet you, and we'll set up an appointment. So, last thing I wanted to look at is the picture. On the very last page there, well, not the last page, but page 12, the answer is yes. Once you're dead, it is too late. That's why we don't charge for reviews. Even if you're not one of our clients and you have your estate planning documents, they've not been looked at, set an appointment, come on and see one of the attorneys. Get a chance to have it looked at. And if it's yours and we haven't seen you in 4 years, look at those things. And if you need to, come see us. Real, real important. Okay? That's it. One of my other partners, Mark Reinhardt, is here now, as some of you will know. We're going to be here answering questions down here upstairs.